An appeal in the matter of Jalla and another, and the shell of international trading and another.
Yes, Lord Goldsmith, we gather that the transcribers haven't logged in, but since the proceedings are being recorded, if they need access to the recording to produce a transcript, they can have it.
That's helpful. But as I understand it, the live streaming is, however, on.
Yes.
Because there are people watching this from outside.
Yes, indeed.
Yes, that's fine. Thank you, my lord. Thank you for explaining that. My lords, I was taking my lords to Ms. K.B. Atemi's witness statement. I want to very quickly finish that point.
Yeah.
The reference is at Supplemental Bundle tab 21, but I can do it quickly and direct my lords' attention to the paragraphs which I believe will be of help to my lords. And they're particularly between paragraphs 36 and 41. 39, for example, sets out the number of spills in the particular area which this case is concerned with. That's the Delta and Bielsa states. So over 4,000 individual spills in that area. And then she gives, from paragraph 40, what's described as a small snapshot of particular spills in that area. And it's over this period of 2014 and 2015. And my lords will recall from the discussion about limitation yesterday, that's a particularly relevant period given where they're trying to go now. But in any event, she then identifies certain spills, and my lords will see, for example, in paragraph 41.1, that she identifies a number of communities affected by a particular spill. Now, this is not a shell spill. This is a spill from a facility operated by NPDC, the Nigerian Petroleum Development Corporation. And over the next few paragraphs, she deals with other companies, Chevron, Adjip, and identifies spills that are there. My lords ask, well, what do we get from this? What we get from this, with respect, is that this will need to be investigated, and the action will be indistinguishable from, somehow, indistinguishable from trying 27,000 actions. And that's what my learned friend accepted yesterday. The transcript references page 86, lines 6 to 12, in answer to my Lord Justice Coulson. So when you say the claimant has to prove damage, has to prove when, in this case that's the 28,000, and my learned friend accepted that. I could take my lords to the detail, but it's not necessary to. But the communities which are identified, for example, as affected by the particular spill, the NPC spill in paragraph 41, include communities which are listed in the schedules to the particulars of claim. And I could tell my lords which they are. Quite laborious process comparing, but they include some of them. And that's just one spill. That's just one spill. So the concession that, we'll have to come to how that actually is achieved, but the concession that it would be the same as actually trying 28,000 actions does raise the fundamental question, in what sense is it said that this is a representative action? That's not what representative actions are supposed to be, and I'll come on to that. But that's a fundamental point. That's why this does matter, this particular point. Miss Atemi, I don't need to take my lords to it. She also deals, if my lords are interested, they may be, when they're rereading into the case, she deals with why an injunction is a particularly difficult remedy to obtain. And she also deals with that's particularly the reference to that in the same, obviously the same witness statement. It's starting at paragraph 46. But of course, we've made the point, and the learned judge picked up on it, the idea that the English court would grant an injunction to cause remediation of land in Nigeria, thousands of miles away, and then have to supervise that is a stretch, put it that way. Okay. So we would submit that when one looks at the differences of facts affecting individual properties, and actually it's not just properties, as I'll demonstrate, it is individuals as well, we can see 7 variables which would be required to be looked at to determine everyone's case. So fundamentally, was the damage of which they complain caused by Bonga oil as opposed to some other source? Either another spill from someone else's pipeline or activities, or just the multifarious acts of third-party interference which lead, as my lords have seen, to a huge amount, actually the majority of the pollution that takes place in the Niger Delta. Secondly, has that person suffered oil pollution damage sufficient to justify a mandatory injunction for remediation? Obviously, the critical question, when did the damage occur? Because that will affect the question of limitation in relation to that particular piece of land. Then we come on, fourthly...
Sorry, but what do you mean just by sufficient?
Well,
I'm not questioning the proposition, just... Do you mean it's sort of a threshold level of damage?
Well, it would be whether the damage...
In relation to this broad remedy remediation?
Yeah, well, it would be whether or not there's damage there which justifies an order for remediation taking place at all. There may have been damage of a transient and temporary nature.
You'd have to... nexus between the damage and the remedy.
Yes, one would have to look at the detail of that. And the example graphically explained put by my noble, my Lord Justice Lewison yesterday, with what if there's a lot of damage in Antwerp, but only spatterings of damage in
the context of a nuisance claim.
Well, in the context,
negligence and violence of electricity.
I think in any claim where an injunction is sought, I would respectfully suggest. So we'll need to do that. Then one would need to look, fifthly, at the...
Sorry, what was 4?
No, this is 4. I'm sorry, it's not 5, it's 4. I'm running ahead of myself. 4 is, does the represented person have the requisite title to land or exclusive possession so as to found a claim in nuisance? The person would need to have exclusive possession and so forth, and all those requirements. The 5th issue would be, in the case of this particular location and, as it were, individual, does that person assert a private property interest, and some of them do, or is this a communal interest? Because that may affect the remedy.
Why?
Well, because whether or not the remedy is available may depend upon what the right is. If the individual is not relying on for example, on a personal right, but it doesn't have exclusive possession, he wouldn't be entitled to a remedy in nuisance. It may be that
that I understand. I understand your title straight
yes.
possession point.
Yes.
But assuming that a community is in
yes.
possession,
yes.
why should it matter?
No, well, Lord, the point I'm making is that and given the emphasis that's been placed on the community element, which we don't actually accept, but that's not just for the moment, it respectfully seems to us that it would be relevant to inquire in relation to a particular claimant, a particular individual. Is that a private interest that's being asserted, in which case the nature of that interest, or is it reliance upon the community interest? So to that extent, one would need to look at that particular parcel of land and what the claim in respect of it is.
Yeah.
And it's one of a list of variables. There's an important next variable, which is, has the remediation work taken place in respect of the alleged damage? And if so, how much and how effective? And the final variable that we identify, and this is our identifying these variables before we've actually had a trial, and it may well become more complicated still, but what would be the cost of the remediation required in relation to that particular parcel of land? Because as soon as you get to damages in lieu, you need to understand what the cost would be. So the fundamental submission, as my lords know, is...
And would land value come into that? I mean, if the remediation cost was 5 times the amount that the land is worth, would that have a bearing?
It could do. I mean, if one looks at the particulars, and we'll do that perhaps a little bit later, if one looks at the particulars of loss that are given, I think they do include diminution in value of land. So my lord is right. That's one of the issues that would need to be looked at. And the important point we would respectfully suggest to stress is that these variables don't just go to quantum, which I think is the way my learned friend would like to present it. They go to everything. They go to the question of duty. Is the nuisance, what line is there? They go to breach. They go to causation. Was it Bonga oil or something else? And they do go to loss and damage as well. So the whole of the claim then results in these variables, which will depend upon the characteristics of the land, and to some extent at least, the characteristics of the individual claimant. So I don't need that piece because it's sufficient in my submission just that that variations in the land would give rise to these differences. That is why my learned friend is quite right to concede. He has no choice but to concede. This will be the equivalent of trying 28,000 individual actions. And we do not understand in what sense that could conceivably be a representative action. We know he wants a representative action, so he gets the benefit of being able to represent a number of people, and the limitation point, don't need to make arguments about what their motivation is, though we have very strong suspicions, but because it's the effect that matters in any event. My lords, before I move on then, I'm obviously coming to the crux of the appeal, but just a couple of points in relation to the proceeding.
Can I just ask you,
yes.
I hope this isn't a philosophical question, what's meant by a representative action in this context?
Yes.
Simply because there might be, theoretically, 27,000 claims which have to effectively be tried in this gargantuan piece of litigation. Does that mean it can't be a representative action? Or does the court simply say, we'll just take a few representative claimants and for administrative committees, we don't have to deal with the other 26,900?
No. Well, that would be a different form of proceeding. That would be, could be a GLO. Yeah. It could be test cases in the context of cases that are pleaded where everyone is technically a party, but then some are chosen. Yeah. The bashing through in the TCC point. But a representative action is different. And this is a point I want to underline. And it may just be worth just reminding my lords I was going to come to it. Just if one looks at the rule critically, what it says happens with a representative action. Because unless the judge so determines, then the result binds all of the represented persons. And that's fundamentally different from a private action or a test case that can be done by agreement. But that is the essence as we look at the cases, and we'll do it briefly given the time. But when we look at the cases, we will see this constant repetition on emphasis on the fact that the essence of the representative action is certain people get bound by the result. Now that's fine if they're all people who are stall holders in Covent Garden, all with the same complaint that the Duke of Bedford is being rapacious and is charging them when he shouldn't. They've all got the same interest. It doesn't actually even matter if they're all part of the action, because it can be decided in relation to all of them. But it does matter enormously once you start to have individual claims in this way. And that's why representative action simply doesn't work. And that's why the judge was quite right to sort of asking Mr. Dunning, well, we having got to the stage where the judge was obviously saw great difficulties on the limitation issues because of the first tranche of the hearing, said, would you like to reconstitute your case? Would you like to have a GLO, group litigation order? And that has been rejected. At least at this stage, whether they come back to it. But if they, but critically, just in terms of procedure, it is a more burdensome process having a group litigation order. They have to keep registers and enter people and so forth. They can't act for people without authority. I'll come back to authority. But fundamentally, they can't do it of their own motion. They have to ask the court for permission to do it. And then the other feature of the representative action is, because remember, actually that means there are representatives. And the representatives are Mr. Jalla and Mr. Tujaw. They're the only claimants in one sense. And the action will take place between them and the defendants.
Well, they are the only claimants, aren't
Yes.
they? Because if there were 28,000 claimants, it would become a question of pure case management.
Yes, my lord.
The point at the moment is that there are two claimants, and the question is, can the claims of the 28,000 be tried through those two claimants?
Yes. Yes, exactly. I think I used the expression there, the lock, or the key to the 28,000. That's exactly right, my lord.
In other words, if Mr. Jalla wins, what does that tell you about the other claims?
Exactly. And if he loses...
And if he loses, what does that tell you about
yes,
the other claims?
yes. Yes, exactly. Exactly. Now, in the protective proceedings, which were started later, and which broadly may take account of the difference in the limitation period, not quite, but you know, they don't have no claim. They've still got the protective claim. There, they are all identified as individual claimants in the schedule. My lords have seen those. And so that then requires case management. And it's in that context that Mrs. Justice O'Farrell has started to give case management directions, and more will be given actually later this month. But there you can look, precisely as my Lord Justice Green suggests at test cases. I think she even raised the question at the last case management hearing. You know, I'd like to know about what issues and how you extrapolate those. That can be done. And if this representative action goes, that will have to be done. With the consequences, it'll still be complicated and complex, and it'll have to be case managed. But what will not happen is Mr. Jalla and Mr. Tujaw standing for the 28,000. Now, my lords also know, I just want to make this point because just to understand a little bit about the procedure, though I'm not sure it matters hugely for the purposes of this appeal. Of course, we say that Mr. Jalla and Mr. Tujaw, the two claimants, are in fact clearly out of time, because in the original judgment, the learned judge effectively said, because the oil will have reached the land within days of the spill, the people who are on the coast, their cause of action will have accrued very shortly after that, and we know that at the very least, that is before April, when there is an attempt to bring in Stasco, without whom the case cannot proceed against any of the defendants. But actually, because of the way that that was done, as my lords know, it's even later date than that, a couple of years later than that. But the fundamental point here is that actually we still maintain that actually the action fails on that ground. And my lords will recall, because my learned friend made this point, we actually made 4 points on the consequential hearing. They're set out in the judge's judgment at paragraph 4 of his judgment. He sets out the 4 points.
We're going to Mr. Justice Stuart-Smith.
Please, my lord. My learned friend mentioned this, my lord will recall. He says in paragraph 4, so what happened was the judgment in March was given. We then said, well, the consequence of that is that all the claims fail. The judge required us to put in an application because the other side insisted on it. So be it. And we then made 4 points, which are set out in paragraph 4. the first three to some extent go together, but because Jalla and Chujo were out of time themselves, they couldn't actually be effective claimants. Therefore, there were no effective claimants. Now, what then happened? My learned friend suggests that we've abandoned that. We have not abandoned that. What happened was the day before the hearing in August, the claimants served entirely new evidence, claiming that though they'd always said that they had land on the coast, they actually had other land as well. I mean, it's actually quite remarkable, as the judge noted, because it would have been very relevant to raise this point earlier. That's not for today. Accept that. And that will be part of the 4-week hearing next February. But be that as it may, we were realistic. Now they've served evidence saying that they've got causes of action which accrued later because they had land further inland and they didn't suffer damage until much later. So we just said, well, we can't ask the judge to decide, therefore they're out of time, without getting into the evidence. And so we didn't pursue at the hearing that point. We certainly haven't abandoned it.
So it couldn't be taken as a point to strike out because there was evidence?
Exactly, my lord, exactly.
But your fundamental point is, if you succeed on that issue, then the whole claim fails because Mr. Jalla and Mr. Chujo, if they are truly representatives, the result binds everybody.
Well, that will be our submission. I mean, we've yet to hear what the response to it will be, other than factually they're not struck out. But yes, we would certainly say that, and we do say that. But it's not for today. I recognise that. And the learned judge noted that we were being realistic in accepting that. And he says that in his judgment. He did say that even if they were still taking the monolithic approach, and my lords know where the monolithic approach comes from, it was all single date because they're all on the coast, and there's lots of evidence of that, their claim, never mind, all of that. But he said even if it were monolithic, it would be a stretch to be a representative. But of course, that's not the way that the case is now presented. May I then turn to the key question of what we say about same interest? Because that's obviously at the heart of the appeal. And they say, my own friend says, oh, well, all the appellants, all the representatives and persons they purport to represent have the same interest for the purposes of 19.6. And the learned judge, having carefully considered it, said, no, that's not the case. Now, first of all, the same interest test is a fundamental requirement. It's a jurisdictional requirement which cannot be dispensed with. Lord Justice Mummery in Emerald, and I don't know whether my lords want to look at it now, I give the reference, but it's at paragraph 62, perhaps we should, given it's the critically important decision.
Certainly the proposition is in dispute, is it?
I'm so sorry.
I'm not certain the proposition is in dispute.
Well, I don't think it is in dispute. I don't think it is in dispute. Well, I don't quite know. The case keeps changing against me. I'm going to come to that point. But certainly, the reference is paragraph 62 of Emerald. The point I wanted to make is that my lords will recall that in Google, the Chancellor said we should take what is said in Emerald as the most recent authoritative exposition of what the same interest requirements are. That's what the Chancellor, as his lordship then was, said. But in so I'm looking just to identify in Emerald at paragraph 62, Lord Justice Mummery says that this requirement is fundamental. looking because I'm finding the reference a little bit surprising. My lords, he says at 62, the fundamental requirement for a representative action is that those representing the action have the same interests. And gives and elaborates that. That's fundamental. In another case my lords haven't yet looked at, and it's just one reference, it's at tab 18, page 564. Well, it starts at page 530, and the relevant quote is at 564. This is also this court again, very different context. It's in the context of court of protection proceedings.
Sorry, page, I missed the page.
Page 530 is the start. The passage is at 564, which is in the judgment of Lady Justice Gloucester. I fully recognise that the context is different, but what she says, it's paragraph 124 of the judgment. She says, having referred to, towards the end of the paragraph, having referred to Emerald, and states that the approach to representative actions is far more flexible than it was in previous decades. Nonetheless, for a representative action to be brought under CPR 19.6, there is a non-bendable rule that the representative party itself has to have an interest in that claim, and that interest has to be the same as that of the party it is proposed the former should represent. And I note each time this is said, the word is same, not similar. And the rule, of course, doesn't use the word similar, it uses the word same. Now, we know that the rule has been relaxed in some respects. We know, for example, that in the early days, the idea that you could have somebody with a different cause of action at all being a representative, that's sort of gone. But that doesn't mean that the requirement that they should have the same interest has disappeared. It hasn't. So it's at this point I do invite my lords to look at the wording of 19.6, which I'm not sure we looked at all yesterday. I'm going to assume that we all have in mind.
I don't think it's in the bundle, but we've got white books.
Exactly. And I know your lordships were looking at it because my Lord Justice Lewison referred to it yesterday.
Lord Goldsmith, I should say, just to clear up any confusion, I don't write it. I edit it, but I don't write it. So therefore, if anybody wants to be rude about the commentary, that's fine. I simply pass that on to the appropriate places.
Thank you. I wasn't actually going to refer to the commentary, though I'm very happy to do so. And I know the question that my Lord Justice Lewison raised about it yesterday. I wasn't actually going to, though I'm happy to respond if it's helpful. I'm conscious of time, and I've got quite a lot still to get through. If your Lordship would like me to, please, I'm happy to do so. In any event, I wanted just to really just draw attention to the terms of the rule. 19.61, where more than one person has the same in a claim. Well, all of those words, it's the same interest, and it's in a claim. It's not the same interest in an issue, for example. Still less a similar interest in an issue. And that reference to claim is obviously important and critical and deliberate, because it then goes on to say then the claim may be begun or continued, or the court may order that the claim be continued. So it must be the same interest in the claim, not a part of the claim, not a similar interest, not a similar issue.
Can I ask something which just slightly baffled me? In the present case, the claimant, the theme that we're looking at, the claimant has genericized the relief sought. It may be way beyond something which the claimant has a personal interest in. So it's not, we've got the individual claims of the claimants, but in the claim that we're looking at, we have claimant and a slightly genericized statement of what the loss and the damage and the relief are. one of the things that I'm trying to get clear in my own mind, I'm not certain I've seen a case on, is whether the interest has to be the same as the claimants.
Yes.
Or what the claimant has claimed.
Yes, my lord, it does. That's what the rule says, and that's the effect of it.
But so in the present case, the pleading, in a sense, straddles both.
Yes, it does, because it's trying to
be
say...
I understand why
Yeah.
and how.
Yes.
I'm just trying to analyse how that fits in with 19.6.
Well,
Does the represented class look at the claimant or what the claimant claims?
Well,
do you see what
well, I see that.
And I know you'll say, well, it's a clever pleading and they've done it deliberately, but so be it.
Oh, I'm not sure I do say it's clever, but never mind. But I think it's come about... Well, I'm not going to comment on that. The point is, the claim here is not just what's in the prayer for relief. What is the claim? In the Duke of Bedford's case, the claim was, I am a stallholder entitled to privileges by statute, you've denied me them. That was the claim.
Yeah.
And it went on to say, so please give me back the money that you've wrongly taken. Here, the claim by these two gentlemen is, my land at this particular place was damaged by all, I'm entitled to certain relief. And what they then seek to do is they seek to somehow slide from that individual claim to something much broader, as my lord says, genericized. But that doesn't mean that this is a representative action. It should be possible to determine at the end of the day, does Mr. Jalla succeed, therefore do all these others succeed as well? Does Mr. Chujor fail, therefore all these others fail as well? That's what a representative action is supposed to be about. We have more sophisticated tools, actually there were in existence at the time of the Duke of Bedford, in group litigation order or case management tools like sample issues, where the court can order that the decision shall bind certain claimants or shall answer the question that certain claimants have got. And we've all done, from bar or bench, cases like that, where that's the way the case management takes place.
When, just trying to, same sort of question I asked Mr. Dunning, just trying to see how this is going to go.
Yes.
Let's assume it's a representative action.
Yes.
And Mr. Jalla produces evidence of damage all along the coast of Nigeria. You, as this work, you say, well, this is not relevant to Mr. Jalla's claim. This is just irrelevant evidence. It shouldn't be admitted.
Well, I would.
Because he's only interested in this parcel of land.
Yes.
He's got nothing to do with land 100 miles further up the coast.
Yes, I mean, he might say, well, I rely upon it to prove that it actually happened, because it happened lots of places, so it's likely to happen to me too. But apart from that, my lord's right. Whereas in a group litigation order case or in a sample case issue, it can be different. And in the protective proceedings, of course, it is different, because that's brought actually on behalf of all of them. And that is why, if we look at the date of damage pleadings, which my Lord Justice Coulson asked for yesterday, we will see lots of witness statements from different people. And in the protective proceedings, that would be, well, I'm not going to concede it, but prima facie, that's legitimate. In the representative action, it's not relevant. So I wanted, and I'm looking at the rule, I did want to, and I think I've made the point, but just to be clear, obviously under 19.6 it happens, the person can do it without leave of the court. They can, under subparagraph 2, be directed not to act, so there's a sort of opt-out or cancelling provision. But under 4, very importantly, unless the court otherwise directs, any judgment or order given in a claim in which a party is acting as a representative is binding on all persons represented in the claim, but may only be enforced against a person who is not a party to the claim with the permission of the court. So there's a filter to protect non-parties. But otherwise it gets applied. And indeed, if I may very respectfully say so, that was the first, my Lord's question was the first question I think that was asked in this court, and it's absolutely key to this. How actually does this happen, Mr. Dunning? And he's never given an answer to that. And that's because he can't. And if we slide into group litigation order or the case management directions that Mrs. Justice Farrell has given in the protective proceedings, that just confuses the issue. That's not the issue before your lordships. My lords, on the authorities, we suggest that the most important actually is Emerald, decision of this court. My lords have it. I don't suggest you turn to it again, but it's tab 14. Let me say this, remind my lords that in the Google decision, Sir Geoffrey Voss, in Lloyd and Google, which is at tab 20, he confirmed that Emerald Supplies is the latest authoritative statement. He did that at paragraph 73, which is page 638 to 639. So that's why we respectfully submit that Emerald is the starting point, and perhaps it's the end point as well. And it is worth just reminding ourselves, if we may please, what Lord Justice Mummery said at paragraph 4, most important perhaps paragraph, it's at tab 14 of the authorities bundle, page 425. I was used to complain about leaders who could never find their papers, but I now understand the problem very well. Thank you to Dr. Blake. So paragraph 4, my lords, where he notes no group litigation order was sought which relates to the jurisdictional or discretionary aspects of an order for representative, I'll say something about discretion in a few moments, requires the parties in question to have the same interest. As Professor Zuckerman explains, the key factor is identity of interest in the relevant group. The identity of interest is determined with a view to promoting the litigation objective of justice, economy, efficiency, and expedition. Although the modern trend is to give the rule an increasingly liberal interpretation so that court can deal with as many claims as possible within one set of proceedings, Professor Zuckerman comments that it's not surprising that the use of this procedure has so far been confined to situations where the interests of the representatives and representatives are virtually the same. I would respectfully submit as a matter of law, it should be not virtually the same, it should be the same. That there may be a little bit of fuzziness as to how you define that. And then this, very importantly, that approach is conditioned by two principal considerations. First, the binding effect of the proceedings on the represented persons who've not given their leave to litigate on their behalf and don't actively or actually participate in the proceedings. And secondly, the limited powers of the court to ensure that the proceedings are conducted in the interests of all the represented parties. Just unpacking those two sentences. First of all, the point that's being made by Lord Justice Mummery is it's the binding effect. He then adds, as it were, after a comma, persons who haven't given their leave to be in the proceedings. But that's not the point. That's what Mr. Dunning wants my lords to believe, because he says, oh, well, in this case, we have got their permission. I'll come back to that. We don't actually accept that. It's a hotly contested issue. But never mind. That's not the thrust of what Lord Justice Mummery is saying. What he is saying is it's the binding effect that gives the representative action its character, as the rules demonstrate. And that's why it has to be, we would say, the same interest. The other consideration, and the second one, is the limited powers of the court. And my lords have seen how, under the rules, the powers are limited. You can order that someone be not a represented party. You can say that their judgment should not apply to someone who was not actually a part of the proceedings. But it doesn't provide for any of the case management powers that exist, for example, in group litigation order cases. So that's a very important part of the consideration. And that's why we say that, and I've said this already, my lords have got the point, I know, that's the binding effect is key to the understanding. save it